May it please the Court, I appear for the appellant with Mr. Bosa KC. Mr. Colvin KC and Ms. Coyne appear for Delta. Mr. Gourier KC and Mr. Feeney appear for Visa. The issue before the Court is whether a licensed PHV operator who accepts a booking is obliged to contract as principal with the person who made the booking to fulfil that booking.
That rather begs the question, your formulation, of what the booking is to do, doesn't it?
We will be coming to that, my Lord. Uber's case is that the answer is yes. It follows from the language of the Act and its public protection objectives. I'm going to start with a high-level description of the issue and how it arises. Then I'll turn to the wording of the legislation. I'll address some core points in the Respondents' case on construction, and then turn to public protection and the wider context. A PHV cannot be hailed in the street, unlike a hackney carriage. A PHV can only be booked through an operator. This is the result of the scheme of regulation set out in the 1976 Act. It regulated PHVs in most parts of England and Wales for the first time. The Act defines the function of operator and the scope of its regulated activities. It regulates the PHV business through what's known as the triple lock. Under the triple lock, operators, cars and drivers all have to be licensed. The operator has a central role in this scheme. It is the point of contact for the customer. It is, on our case, the operator's responsibility to arrange for the fulfilment of the booking. It also has to ensure that the car and driver are both licensed under the triple lock when they do so. The purpose of all of this is the protection of the public, both before and after the PHV arrives. The regulated function of the operator, therefore, begins long before the car arrives. And that regulated function carries with it important regulatory responsibilities, such as record keeping. But the acceptance of a booking also brings with it contractual obligations. In the language of this court in Aslam, acceptance of the booking connotes the entering into of a contract. In our submission, that contract is an obligation to provide the hire service that has been booked on the terms agreed at the time. This is a personal responsibility of the operator that the customer chose. The contract is to be performed on the terms of that operator. And that remains the case even if the operator subcontracts fulfilment of the booking to another operator. Now, those terms of the contract are subject to control under the general law of consumer protection and indeed under control of licensing authorities. And Uber's terms are criticised by D.E.L.T.A in this regard, but I will show the court later they contain a commitment to deliver the transportation service subject only to narrow and transparent limitations. They provide valuable protection to the customer, entirely absent on the respondent's analysis. Indeed, both respondents say, on accepting the booking, an operator can choose to enter no contract for hire. They say at that point they've made no commitment at all to the customer as to whether a car turns up at the right place and at the right time. Now,
well, those two aren't mutually exclusive, are they? I mean, a lot of the problem in this case seems to pin down exactly what the real differences are.
The differences on what, my lord?
Between the parties.
Well, in my respectful submission, that is the core difference between the parties. Is there a contractual obligation to fulfil the booking, or is there not?
Well, I'm not sure we'll find out whether respondents deny that a contract is made when a booking is accepted. Maybe they do or they don't. But then it's a second question what the nature of the contract is and whether you, I think, are saying that it must be a contract for hire.
Yes.
And it can't be any other kind of contract.
My lord, exactly. We say acceptance of a booking implies a contract of hire.
And you say it's with the person who booked?
Yes, we do.
Even if that's not the passenger?
No, the person who booked may or may not be, for example, booking it. So let me distinguish. A restaurant, for example, or a hotel may make the booking, but obviously as agent for the person who seeks the booking.
Okay.
But my Lord Legate's point is, with great respect, right. There is mystery about exactly what the respondents concede. D.E.L.T.A accepts at some point a contract for hire must arise. And that's paragraph 69 of their written case. We will come to it. After all, this is a transport service provided for reward. It's hard to see how it could not be contractual. And at that point, they also say that contract arises with the operator too. But I will come to this. Exactly how and on what terms this is supposed to happen is all a mystery. Uber's case is much simpler. When a contract is accepted by an operator, a contract for hire arises then and there. It follows from the statutory language, but it's also effective for attaining the public protection goals of the Act. In our submission, it avoids a significant lacuna in that scheme of public protection. And before turning to the Act, I wanted to just take a moment to ground the dispute in practical realities with a concrete but anodyne example. Consider a customer in Manchester who chooses a PHV operator, ABC Cars, to book a trip from their home in Manchester to Manchester Airport on 9 a.m. on Saturday. ABC Cars checks a PHV is available and confirms the booking with the passenger. In so doing, ABC is carrying out its regulated function as PHV operator. And of course, nowadays, this might all take place on an app, like Uber's or D.E.L.T.A's, but the inherent nature is the same. On Uber's case, ABC has accepted the booking. It's entered a contract with that customer for hire of the PHV. It's agreed to provide the transportation service requested in consideration for agreement to pay the fare. As a result, the customer has immediate protection and clarity that a contract affords with the operator of choice. But on the respondent's analysis, and indeed the Court of Appeal's judgment, this interaction does not need to give rise to any kind of contract for hire with ABC Cars. There's no contract to transport at all at that stage. And it may be that if a contract arises, it is with the driver, when the driver picks up the passenger. But the driver is someone the customer will likely know nothing about on terms the customer may know nothing about. And according to the respondents, the Court of Appeal, sorry, I've already said this, it will only arise when the car arrives to pick up the passenger. Now Visu's terms and conditions are an example of this in action. They say exactly that. And if it would be assistance, I will just show you briefly what they do say. It's under tab 82 of the core volume.
If it's not inconvenient, I'm using page numbers.
I'm sorry if that's more helpful.
Sorry, the page was
2052.
Sorry. I'm so sorry, I've already got the reference wrong. It's tab 89, and it's page 2122. This is Visu's own terms and conditions. And you'll see at the top, the following terms and conditions apply when you use our booking service, as they describe it. And if we could please turn to page 2123, it's clause 7. On making a booking, a licensed private hire vehicle driver or hackney carriage driver, a driver partner will be assigned to your booking and will be responsible providing you the transport services. Details of the driver partner and their vehicle will be provided to you shortly after your booking is made. So the booking is completed, then the driver is assigned. And then they say, in legal terms, the contract for the transportation service is not made by the booking, but is subsequently made between you and the driver partner when your driver partner collects you. So according to Visu, that is the moment of contractual formulation. The contract for transportation services is between you and your driver partner. We are not party to it. Now, that last sentence is wrong in law, even on D.E.L.T.A's case. But here we see Visu dissociating itself from any obligation to deliver the transport service. And indeed, it confirms this at paragraph 8. We do not provide transportation, logistics, delivery, or other services. And then just to complete this picture, if we turn on to 2125, paragraph 23, please note, we do not accept any liability for any bookings which result in late arrivals, etc. So according to Visu, a contract arises when the passenger gets in the car. And that way, they avoid any responsibility for performance of the transport service. But
well, they don't once the driver has got in the car, then they're on the hook.
Well, it's not what their terms say, my lord. We would agree, and we will come to that. But it's notable their terms actually say the opposite. But obviously, I fully appreciate we're not here to litigate Visu's terms. I offer it simply as an example. But matters get more complicated because, as is common ground, ABC Cars is permitted to subcontract that booking to another operator. And there's no requirement under the Act that that subcontract should be disclosed to the hirer. So, a car may turn up with the logo of Z Cars of Preston instead of ABC Cars. And so the contract may be with a driver chosen by Z Cars, presumably, we don't know, on that driver's terms, or perhaps Z Cars' terms. And suppose Z Cars' driver never turns up. If the respondents are right, no contract for hire may ever arise. That is indeed the purported effect of Visu's terms. There would be recourse through enforcement by the local authority. A complaint might be made. If there were enough complaints, the local authority might eventually suspend the licence. But as I will submit later, that is not a practical or individual remedy.
Well, is that so different from having a contract where you do take on the carriage, but then you have a right to cancel that without charge?
Well, my lord, rights to cancellation are of course governed by the common law and indeed the statute law of consumer protection. They don't allow an operator to just cancel willy-nilly. I will come to that too later if I may. And I accept this is just an example. There's evidence before you of how these two particular operators work. But our submission is that all of these services involve the core obligation upon an operator to provide a car with the services of a driver for hire. And before I turn to the Act, I want to just say...
Just a moment.
My lord.
We're here, as I understand it, to decide whether the Court of Appeal was right to say that the Act does not mandate that structure.
Absolutely.
Thus far, you've been looking at a particular structure and saying it's a core obligation of that structure that there is an obligation to provide the carriage. I mean, if there was, we wouldn't be worrying about whether the Act mandates it or not. I thought we were proceeding on the basis that these two structures don't in fact do so, and the question is whether they're in breach of the Act by not doing so.
My lord, that is exactly the question. The purpose of the example was simply to illustrate the consequences of the respondents being correct. It is absolutely our submission that the Act mandates that acceptance of a contract implies a requirement to contract with the customer as principal. That's what I'm going to come to in a moment. I thought the example would be helpful in just crystallising in practical terms what this difference between the parties really means. On our case, Visu and all other operators are indeed obliged to contract as principal when they accept the booking.
Yes, by the Act.
By the Act.
So the search is for something in the Act that creates that obligation.
That is, my lord, exactly.
Or a prohibition on doing it in any other way, might be another way to put it.
Exactly so, exactly so. Before turning to the Act, though, I was going to say just something about how we got here today. Because the respondents say it is significant that this point arises now for the first time on the 1976 Act. But as the Court knows, the issue of the compatibility of the agency model with PHV regulation in London arose in this Court's judgment in Aslam. Now, that case was, of course, centrally concerned with a different question, namely the employment status of drivers. But it put the spotlight on the issue. And indeed, in that case, the long-established practice of the agency model was raised as an objection, but without success. That judgment, in turn, led to proceedings in the Divisional Court in 2021 in respect of the London Act. And at that time, the London Act of 1998 had been in force for more than 20 years. The regulator, TfL, explained to the Divisional Court it hadn't reviewed the contractual terms of the 1,900-odd operators in London when licensing. But the Divisional Court granted a declaration in similar terms to the one sought in these proceedings. The practical effect was to prohibit the agency model in London for the first time. And the question for this court, of course, is whether the same approach applies under the 1976 Act. And that is, of course, a question of pure statutory construction. Now, it's well established that the object of this part of the 1976 Act is public protection. That much is common ground. I wanted, if I may, to show the court one authority that establishes this, which is St Albans and Taylor, and the page number is 1508. So the judgment begins at 1505. And we can look very briefly at the facts, which are between E and F. The defendant, a licensed operator of a private hire business, was on 2 occasions left short-staffed and unable to meet his pre-existing bookings. At request of his wife, who was not licensed as private hire car driver, he drove pre-booked customers.
At his request, his wife...
I'm so sorry, I misread.
His wife did the driving.
His wife did the driving. Drove pre-booked customers to their destinations in her own vehicles, which were unlicensed. His wife told the customers the journeys were free of charge. The defendant was nevertheless charged with offences of operating an unlicensed vehicle and driver. And then the dicta of Mr. Justice Hodgson we rely on is at page 1508. And we can see it between A and B. The underlying purpose of Part 2 is clear. It is to provide protection to members of the public who wish to be conveyed as passengers in a motor car, Lord Justice Russell, in a motor car provided by a private hire organisation with a driver. This vehicle has to be licensed before it can be used, and so forth. So that phrase, in our respectful submission, accurately captures the position. And indeed, it's just worth noting at 1509, at G, Mr. Taylor, the operator, explained he'd arranged for the carriage of his customers in order to fulfil what he regarded as his contractual obligation. Without that contractual obligation, he would not have carried his customers. So this is a case about the function of the operator prior to the passengers entering the vehicle. But of course, I don't rely on that case as the answer to the question before your lordships. One way to frame this dispute is about the breadth of...
I'm sorry for interrupting. When one looks at public safety, one turns to the provisions of the Act, and that's what happened in this case.
Yes.
And there are obvious public safety implications in the triple lock. Where do we find public safety in relation to the requirement to have a contract? Which part of the Act do we turn to? Well, or perhaps you're coming to it later.
My Lord, our answer to that is that in the interpretation of the Act we find the contract, and the contract serves the objectives of public protection. I am not arguing that because public protection is a good thing, that must be what the Act means. I'm grateful for the question and the opportunity to clarify that.
But how does it do that insofar as if it serves public protection to have a contract, you can have a contract on any terms you like, and it may give absolutely no protection whatsoever to the individual. Whereabouts in the contract do we find, in the actual Act itself, do we find public protection by virtue of a contract?
Well, the Act serves the objective of public protection. It is our submission that the Act requires a contract, and it is our submission that a contract would further the aims of public protection. There is not an unlimited ability on the part of operators to carve all content out of that contract. It's a contract for hire, a contract for transportation services. Both common law and statute law allow some limitations upon such contracts, but not to any degree. The Consumer Rights Act, for example, places strong restraints upon the ability of consumer contracts to be contracted out. But if I may, I'll come to that later.
But St Albans was really only about the public purpose of the Act ensuring that if you get into a private hire vehicle, A, the vehicle is properly regulated, and B, the driver is properly regulated.
Absolutely.
And neither of those conditions were fulfilled in that case because it wasn't a properly regulated vehicle and the driver herself wasn't properly regulated.
My Lord,
it doesn't really say anything, does it, about what further form of public protection may be provided, for example, in not having to wait for a vehicle that never turns up?
no, it says nothing about that. I rely on the general formulation of what the purpose of the Act is. But I fully accept I have to do the work now of persuading you that the Act itself does indeed require contracting. Now, I'm going to turn to the Act now. It's relevant that we're concerned with Part 2 of the 1976 Act, which is adoptive. It's in fact been adopted by all district councils throughout England and Wales, except Plymouth, which has its own similar Act, and of course London, which we will turn to. It was adoptive because the Act also added requirements to existing hackney carriage legislation, which was itself adoptive. And because that hackney carriage legislation does not apply to London, it couldn't apply to London either. I can show you that, or just for the transcript, it is section 45.2 of the Act. But I wanted to... my Lord, it's page 384.
Thank you.
And I wanted to turn against that background to the triple lock, which is page 386. And I appreciate the court will be familiar with this, but it's very important, of course, to the argument. It's section 46. And as you will have seen, except as authorised by this part of the Act, no person being the proprietor of any vehicle, in respect of which a licence is in force, shall use or permit the same to be used as a PHV without a licence. So that's vehicles. Then drivers at B, no person shall in a controlled district act as a driver without having a current licence. And then D is operators. No person shall in a controlled district operate any vehicle as a PHV without having a current licence under section 55. So that is the operator part of the triple lock. But we also see at E, no person licensed under section 55 shall operate unless both the vehicle and the driver are licensed. So there we see an overarching responsibility of the operator as parts of the triple lock. And then there follows in the Act the various licensing provisions. But I want to just deal now with the provisions on subcontracting, because they are going to prove important in the submissions of both sides. And we pick them up at page 406, please.
406.
406.
Thank you.
And this is a section entitled Subcontracting by Operators. And you can see it's by amendment, and it was by amendment by the Deregulation Act 2015. And it served the purpose of deregulation by liberalising the existing practice of subcontracting. And it is common ground that the practice of subcontracting predated the 1976 Act. Indeed, it's identified in the Maxwell Stamp Report. But case law had established it was confined to the use of vehicles and drivers licensed in the same district as the accepting operator. And the 2015 Act removed that restriction. But 55A1A addresses the form of subcontracting that was already permitted. it is a restatement of the existing law. If I can show you that. So this is page 406. A person licensed under Section 5 who has, in a controlled district, accepted a booking for a private hire vehicle may arrange for another person to provide a vehicle to carry out the booking if A, the other person is licensed under Section 55 in the same district, so that was the existing ability to subcontract. B, the other person is licensed under Section 55 in another district, that's a new freedom. C, the other person is a London PHV operator and the subcontracted booking is accepted in London. Or D, the person accepts the subcontracted booking in Scotland. Scotland has its own regime, which I can take you to later if it's of assistance. But aside from Scotland, all of these are powers that enable the subcontracting with another operator. And then we see at 55.2 another provision that's going to be important. It is immaterial for the purposes of subsection 1 whether or not subcontracting is permitted by the contract between the person licensed who accepted the booking and the person who made the booking. And then 55A3, where a person licensed under Section 55 is also licensed in respect of another controlled district, subsection 1 and so forth apply as if each licence were held by a separate person. So it allows for a form of subcontracting, if you like, within a legal person. But that is obviously a pragmatic measure reflecting the fact that the same operator may have branches. And against that background, I want to turn to what really is the core of our submission, why we say acceptance of a booking is inherently contractual. And I'm going to deal with 3 provisions of the Act that I haven't shown you yet. Section 80, Section 55A2, which I did just show you, and Section 56. I'd like to start with Section 80, which is the definition of operate. And could we please turn to page 451? This is the beginning of the definition section, and it's entitled Interpretation of Part 2. And it has that title because Part 2 is the relevant part of a Miscellaneous Provisions Act, and the other parts that we're not concerned with today deal with miscellaneous matters. And then the definition of operate is on the next page, about a third of the way down. Operate means in the course of business to make provision for the invitation or acceptance of bookings for a private hire vehicle. So we can read the definition of private hire vehicle into that, and that definition is a vehicle provided for hire with the services of a driver. So this makes clear, of course, that we're not concerned with car rental. A PHV is a vehicle provided for hire with a driver. And a person who makes provision for the hiring of a car and driver in this way is an operator. And the concept of hire is itself inherently contractual. Our submission is a person who accepts a booking for a vehicle and driver provided for hire has contracted to provide the hire services. And of course, these concepts of invitation and acceptance are recognisably common law contractual terms. Acceptance of a booking is not merely writing the booking down in a ledger or noting a customer would like transport to the airport. Our submission is the concept of acceptance involves a commitment that the booking will be fulfilled. Now, it needn't be fulfilled personally, as I've shown the court. It can be subcontracted to another operator. But a booking cannot be accepted in this sense without agreement to perform it. And as my Lord Legger observed in giving the judgment of the court in Aslam, that acceptance has to be personal, not merely for someone else. Acceptance is the regulated function. That's why the operator must contract as principal. Now, the respondents say acceptance of a booking is not the same thing as contracting for hire. And Mr. Colvin KC ran a similar argument in the divisional court in the London case, and it was rejected. The court said the difference was illusory, and just for the note, that's page 1473, paragraph 25 and then 28. Our submission is that acceptance is one element of contractual formation. There may be invitation to treat, offer and acceptance, thinking back to the example I gave you. But once there is acceptance of the booking, this gives rise to the formation of a contract. This is simply ordinary common law.
Well, if it's possible to organise private hire vehicles in a different way that doesn't involve entering into a contractual commitment to provide the vehicle and the journey, then on the submission you've made thus far, that kind of service would fall outside the definition of operate, and everybody who was running that kind of service wouldn't be an operator under the Act or caught by the regulatory regime. That part of it which affects operators.
Well,
let me finish. In other words, it would be a narrower definition of operate than one which would catch persons who arrange bookings, even if not in a way that contractually commits them to providing the vehicle. And on the face of it, one would be surprised if Parliament had intended to exclude from regulatory control businesses that do it that way.
My Lord, the critical question on our submission is whether that enterprise is accepting the bookings. If it is doing something else that doesn't involve acceptance, it's not an operator.
Well, then if it's not an operator, it's not regulated, and that would be an extraordinary result.
Well, I should back up from that, if I may. May I give that answer again, but qualify it? Operate means make provision for invitation or acceptance. If you're doing either of those things, you are an operator. If you're not doing either of those things, well, you're doing something else. I fully accept. If you're not involved in invitation or acceptance, you're not an operator. If you're only involved in invitation, whatever that would look like, you are an operator, but you're not accepting bookings, and therefore you're not entering a contract. It is the word acceptance that we locate the obligation to contract in.
But if on the true construction of the terms and conditions offered by the respondents, they are not contractually accepting an obligation to provide the vehicle, they may be regulated because they invite it, but not otherwise. So why does this definition of operate impose a prohibition on doing it any other way than by contracting to provide the vehicle?
It's clearly right. There could be questions of fact about whether or not an undertaking is or is not accepting bookings. It's not, as I understand it, the respondent's case that they don't accept bookings. It's their case that acceptance does not carry with it the connotation of contracting. Yeah. So, of course, one could imagine that some ingenious structure involving multiple companies or something might involve a particular entity, for example, promoting PHV services, i.e. inviting bookings, but not actually accepting them. If that is the case, so it's not ABC Cars of Manchester that says, yes, the car will be there at 9 o'clock, they're not accepting bookings. That may well be the case, my Lord, but there will be complex factual cases in and around these definitions on whoever's interpretation the court decides to accept, or indeed on something else. I wanted now just to turn to the second indicator we rely on as demonstrating an operator who accepts a booking has entered a contract. And this is back on page 406, in section 55A, again. And this time...
And for the avoidance of doubt, your position is that they have to enter into a contract as a principle.
Yes.
They can't simply do it as an agent for the driver.
Exactly. And we respectfully adopt the words of Lord Legate in Aslam that were to that effect. That is the regulated function. One cannot as it were, leave the substance of the regulated function to somebody else. May I turn now to 55A2, which is at page 406. I showed you this briefly. This is, to remind you, the section dealing with subcontracting. It is immaterial for the purpose of subsection 1, i.e. subcontracting, whether or not subcontracting is permitted by the contract between the person licensed under section 55 who accepted the booking and the person who made the booking. In our respectful submission, that unambiguously proceeds on the basis that a contract does arise between an operator and a hirer on the acceptance of booking.
Well, as Lord Legate said, that begs the question as to what the contract is or is for.
Well, with respect, my Lord, what it says is the contract between the person who accepted the booking.
Yes.
So, indeed, taken on its own, I accept. There could be a question about what that contract consists in. That's why this submission is not, it is additional to the points I've already made on section 80. But I just want to make clear.
As I understand it, you don't contend that the contract is always with the person who made the booking. You say that that person could be acting as an agent for
well, the person
other people.
who made the booking means the person who was the principal. I fully accept there could be an agent. If a hotel reception rings up on behalf of a guest to book a car for the airport, in a physical sense they have made the booking, but the person who has booked is the passenger.
Say the hotel's got a party of 9 people that will fit conveniently into a vehicle, and you then have complicated questions as to who it was who made the contract on behalf of those people who want to be carried.
There could be factual complexities, but to take a step back from those questions, it's the respondent's case that it's perfectly lawful under this regime for an operator to enter into a contract of hire. They say it's not mandatory. So on any view, there will be factual complexities about who the contract is with. PHV business involves many different factual variations. In my respectful submission, the fact one might need to look carefully at the facts on an individual case goes nowhere to undermining the core proposition that we advance.
Can I ask, are you arguing that the regulatory purpose of requiring the operators to be licensed would be undermined in the absence of a contract, or are you saying that it simply follows as a matter of textual analysis of the statute that there must be a contract?
I'm going to put those points in the opposite order. We say that it follows as a matter of statutory construction that there is an obligation to contract. That furthers the scheme of public protection, and if we are wrong, there is an important gap in that scheme of public protection.
And you're going to come on to address us on the public protection aspects and why the existence of a contract matters.
Absolutely. Fine. I'm going to deal with all of these questions of construction first, then I'm going to come to that.
Fine.
I was just before we leave...
For your argument, you don't really need to have a public safety requirement. No. You just say there is a contract when a booking is accepted.
My Lord, yes, we're mindful of the case law of this court that interests itself in wording, purpose and context. We intend to address them all. But just finally on 55A2, if I may, I said this was a deregulating section. It wasn't in the Act as originally adopted. This reference to the contract is not itself a new introduction. It simply reveals Parliament's understanding of the role of the operator. It proceeds on the understanding that accepting a booking involves making a contract for hire. The deregulating effect of this subsection was to make clear that contractual provisions that precluded subcontracting could be overridden. That is the deregulating element.
Well, it doesn't weaken the regulation, does it? Because the subcontractor has to themselves be a a licence?
Yes, oh, absolutely. I'm simply tackling the point that 55A is a new interpolation in 2015. But the idea that the operator contracts is not introduced by 55A2, it is reflected in it. It is Parliament's understanding that there is such a No one has argued before this court that 55A2 introduces an obligation to contract.
I mean, is it the use of, I mean, I'm trying to understand what the argument is. Is it the use of the word subcontracting that implies that there must be a contract?
No, it's the use of the word, I mean, obviously on its face that does, but I fully accept that 55A4 anticipates more informal forms of subcontracting because it allows for subcontracting within a single legal person. So if ABC Cars also has a branch in Liverpool, it can subcontract within its branches, even though they're a single legal person. That's why, my lord, I don't put much weight on those words in themselves. The point I'm making at the moment is the reference in 55A2 is significant to...
You're emphasising the word contract in that.
Yes. My lord, it really is as simple as that. And I was going to now, if I may, turn to the third provision that is important in this argument, which is section 56.1, which, if I may say, looks innocuous but has led to a great deal of disagreement between the parties. And that's on page 409.
I'm sorry, so it's really the 55A2, which you say the wording is based on the premise that there is a contract
Yes.
between the operator and the person who made the booking.
Yes, that's it.
Well, if it, yes, in that slightly loose sense that it could also be between two branches of the same legal person.
Well,
That would be the subcontract.
Only the subcontract.
Yes.
so there's informal subcontracting envisaged by 55A4, but 55A2 is not about that.
No. Well,
That's the submission. And I was going to turn, if I may, now to 56.1, which is at page 409. 56.1. This is a section also dealing with operators, and all of the provisions here are of relevance to the issues your lordships and your ladyship seek to decide. But 56.1 is the focus of this part of the argument. For the purposes of this part of this Act, every contract for the hire of a private hire vehicle licensed under this part of the Act shall be deemed to be made with the operator who accepted the booking for that vehicle, whether or not he himself provided the vehicle.
yeah.
And it's useful to read this with 56.2 and 3 before I start making submissions about it. Because 56.2 and 3 are about record-keeping obligations. Keeping records of bookings and invitations for bookings are important for public safety, obviously. If something goes wrong, the local authority or even the police may need to know. And if we look at 56.2 first, every person to whom a licence has been granted, an operator's licence has been granted, shall keep a record in such form as prescribed. And then in the third line, before the commencement of each journey, such particulars of every booking, invited or accepted by him, whether by accepting the same from the hirer or by undertaking it at the request of another operator. And one way that might happen, of course, is through subcontracting, undertaking at the request of another operator. Or it might simply be that ABC Cars rang up Z Cars of Preston and said, can you take this job, and put the hirer directly in touch with them.
Well, this section precedes the amendment that allowed subcontracting, so we have, I think, to assume, don't we, that it's probably the latter.
Yes,
In
well,
its original form, but it's good enough for both.
And Mr. Justice Dyson, in a case we're going to come to, found exactly that, my lord, that 56.1 and 2 provided the statutory authority for subcontracting.
At first sight, 56.1 might be thought to be against you.
Well, that's what the other side's saying. I'm going to come to that in a moment. And then just to complete the picture, 56.3, every person to whom a licence in force under Section 55 has been granted by District Council shall keep records of, and then any private hire vehicle operated by him. So what do we say about 56.1? Firstly, something uncontentious, I think. By reference to every contract for hire, being deemed made by the operator who accepted the booking, it obviously presupposes the existence of a contract for hire. And indeed, it also makes clear that it is an operator that accepts the booking. But the issue, of course, is what the real effect of this deeming provision is. Our submission is a very simple one. I'm going to show you in a moment why the respondent's submission is anything but. We've already seen subcontracting is permitted under the 1976 Act. The deeming provision serves to make clear, for the avoidance of doubt, that the contract for hire is made with the operator who accepted the booking, notwithstanding any other arrangements to fulfil it.
But it can't have been, the point that Lord Briggs just made, that 56 predates 55A, so
Yes.
56 wasn't drafted with subcontracting in mind.
Well, my lord, that is a submission I hope to have anticipated,
Right.
because subcontracting was already allowed before 55A under the Act, and indeed 56(1) and 2 is where one finds that made clear. In fact, it was a practice that pre-existed even the adoption of the Act. It wasn't created by the Act. It was already prevalent in the private hire vehicle trade. So in our respectful submission, it is a premise of 56(1) that there will be subcontracting, and 56(1) makes clear that even when that happens, even if the passenger finds that a car from Z Cars of Preston turns up and is wondering what the situation is, 56(1) gives the answer. If Z Cars driver turns out to make errors, or indeed Z Cars never even turns up, it is 56(1) that says your claim is, or your right is against ABC cars. It is for the avoidance of doubt. And it's also for the avoidance of doubt if you face terms such as those of visu, which say, well, the operator isn't a party to this contract. Now, what the respondents say is there's no need for a deeming provision if Uber is right and a contract with the operator is required. But I do say two things. Firstly, the deeming provision is to avoid a lack of clarity about where the remedy lies. But even on their case, there is redundancy in this provision.
But sorry, you say it's for the sake of clarity as to where the remedy lies.
So in other words, the hirer, they think they've booked with ABC cars, Z Cars of Preston turns up, 56(1) says, no matter what has happened to the fate of the booking, you have a contract of hire with ABC cars. That is the doubt that it eliminates. But the respondents say, well, it's redundant because on your case, Uber, there is already a contract for hire arising as a result of acceptance. But it's also right, though, that on their case, there is redundancy because they say an operator who accepts a booking is free to contract, even though they say they don't have to. But if an operator does so, on their case, this provision is seemingly redundant.
Well, is that right? Another way of looking at it is that this provision assumes that you can do it either way. That is, if you're the operator, you can accept a booking contractually so as to provide, being under an obligation to provide the vehicle, or not, as the case may be. But section 56(1) says, whichever way you do it, for the purposes of the regulatory scheme, you're being treated as having contracted to provide the vehicle.
Well, that is the respondent's submission.
Yes, but I mean, well, okay, maybe it is, but
It's not an
I'm
argument
not sure you
for
can describe that as partially redundant. It's effectively saying because acceptance is a basically quite wide concept that doesn't necessarily mean contracting to provide the vehicle, and because the contract which the Act assumes you're making with the customer isn't necessarily a contract to provide the vehicle, therefore this tightens all that up so that it makes no difference.
Well, my lord, I hear what you say. If the contract is in fact with the operator, then this provision would not be needed. I don't go further.
No, sure.
I go no further. Perhaps I put it infelicitously. I was hoping now just to show you a passage from the Maxwell Stamp report, which deals precisely with this in eerily similar terms, if I may. And that is a page. Sorry, if I just want to make sure I get the right page reference. The Maxwell Stamp report starts at page 1678, but I want to go just directly to what it says about this deeming provision, which is under its recommendations. And it's at page 1785. In fact, perhaps we can look at 1784, because we can see there, this is a scheme of control for the private hire car trade. And what I wanted to show you was 9.6 and 9.9. 9.6, we considered whether it was in fact necessary to license car hire operators, but it came to the conclusion it was essential to do so. In the private hire business, the operator, and not the driver, is the person with whom the hirer makes his contract. And it is surely right, he should be held to have an overall responsibility for the way in which that contract is carried out, whether or not he owns the particular vehicle or employs the particular driver used. In other words, subcontractor. And then we can see that at 9.9, please, on the next page.
But that would be achieved by the deeming provision, wouldn't it?
Well, that's,
it doesn't.
my lady, that's exactly where we're going.
But it doesn't mean that it doesn't require a contract to be made as principal.
Well,
if the deeming provision.
May I deal with the point separately, if I may? But your ladyship's obviously right, and I'm seeking at the moment just to show you how Maxwell Stamp envisaged a deeming provision might work. And it's at 9.9. We do not wish to put a stop to the useful practice of arranging for another operator to provide a car in order to avoid losing a customer. But the operator who passes on a booking ought no longer to be able to do so without having to accept full responsibility for the standard of service provided. We therefore recommend that the scheme of control should include a provision to the effect that where an operator himself undertakes to arrange for a vehicle to be provided, whether by himself or another operator, the hirer's contract is to be deemed to be with the original operator and the fare chargeable on his normal basis. I show you that because it is entirely aligned with the submission that I'm making about the meaning of section 56.1. I obviously don't press Maxwell Stamp hard. It's not a white paper or a ministerial statement, but it does, in my respectful submission, correctly identify the mischief at which the deeming provision is aimed. Now, I want to say something about the Respondents' case on section 56.1 now, because in my submission it's much more ambitious and unclear. They are forced to accept, as they do, or at least D.E.L.T.A does, as a result of section 56.1, the operator must at least be a party to a deemed contract of some kind. That's inescapable for them. But the question is, with who and on what terms? Now, D.E.L.T.A, at least, accepts there has to be a contract of hire with someone. This is paragraph 69 of their case at page 115, but I'll just read the sentence out. It's in the core documents bundle at page 74. Paragraph 69. I'm just going to check I've given you the right reference.
You have.
Thank you. By the time the hiring takes place, there is a contract of some sort in place. It is inherent in the notion of hire. We certainly agree it's inherent in the notion of hire, but you had my submission on that about half an hour ago. But on their case, as you know, that contract need not be with a party who accepts the booking and is licensed to do so. On Visu's case, as far as we can tell, the contract need not even be with the driver. So we're contemplating a scenario where an operator has accepted the booking to go to the airport on Saturday, but there may be no contract until the passenger gets in the car, according to the respondents, or some other time when something else happens. That act of getting in the car is said to be the act of formation with another party who has not accepted a booking, who the hirer has not dealt with, and potentially on terms unknown to the hirer. So that contract may well indeed need to be implied in reality. But the deeming provision now arises, according to the respondents. So when that passenger gets in the car, the operator who accepted the booking is deemed to be a party to the contract of hire. That's the respondent's case, that this is a permissible arrangement. But this raises important further questions. Is that deemed contract a freestanding contract, deemed only made with the operator? Or does the operator become party to the contract with the driver? Is the nascent contract with the driver, formed when the door opens, somehow transformed as soon as it arises into something else? And on whose terms is this deemed contract? The driver may realistically have no written terms. It might actually be entirely implied. Now, Parliament obviously thought it was important that there should be a contract with the operator, we would say irrespective of subcontracting. But it's hard to understand why, if it thought that, it would leave so much unsaid or to be implied if that was the correct interpretation of Section 56(1). But Delta makes another important concession about this contract I'd like to show you. And this is in the key documents bundle, page 79. And I'm going to show you a series of sections to show that what they accept is there would be an enforceable contract of hire. And I'll just trace that through. In paragraph 84, they say Section 56 was drafted in recognition of the different ways hire contracts come into being. And then in 86, they say in the third line, a neat device preserving contractual freedom in a complex market, giving contractual recourse against the operator. And then moving on to page 88 in the key documents bundle, paragraph 123, they say, if they do contract with the driver, a passenger has remedies against both the driver under the actual contract and the operator under the deemed contract. And then finally...
I'm having some trouble because it looks as if the pagination of the key documents bundle is different from the pagination of the main bundle, and I'm operating on the main bundle.
It is. Can I just go back and give you the main bundle references for the same passages?
It's all right. I've been helped by my...
I'll try to give both references.
Please, if you would.
So the next one I was going to show you is page 135 of the core volumes and 94 of the key documents bundle. And it's paragraph 137. And having cited Marshall, Inspector of Taxes, they say the consequence of enforceable contractual rights inevitably flows from a contract having been deemed. So Delta concedes that the operator is a party to a contract enforceable in private law for the supply of transportation services. But they say even though the customer has apparently reached agreement with the operator when the booking is accepted, contractual protection can be deferred until much later, dependent on a transaction with an unknown driver and potentially on unknown terms. Uber's case is much simpler. When an operator accepts a booking, it enters into a contract. The entity licensed to accept the booking does so. When it does, the contract of hire is formed immediately. It is formed on terms discoverable by the hirer at the time, and the deeming provision makes clear that all of this will be the case, even if that operator enters into an undisclosed subcontract with, say, Z-Cars of Preston.
Well, it's not necessarily discoverable on terms available at the time. If we look at the terms that we see, the terms have showed us as suggesting something you say is incorrect.
Well, indeed, absolutely. But
the only difference between you and Delta seems to be the timing.
But it's not, with respect, my lord, it's not the only difference, at least so far as we can glean from their written case. There are questions that are unanswered about the nature of this contract.
Well, it's a contract for the hire of a vehicle. If there's no other terms agreed, it's all the implied incidents that would come with that.
So then they are stuck with an implied contract, just as they say we are. In other words, the premise of their case is some other form of, we would say, quite mysterious implied contract that has to arise in order to give effect to their argument. Yep, that's precisely the criticism they make of us.
Do we have their terms?
Delta's? No.
Delta's terms, yes.
We actually don't.
the deeming provision doesn't seem to do any work at all, because if you have, if it is meant to deal with subcontracting from one operator to another, you don't need to have a deeming provision. If you've entered into a contract with the operator and he decides to subcontract the performance of that contract to somebody else, you don't need to have a deeming provision to say, by the way, there's a contract with the operator.
Indeed, it is...
Your case is that it's for the avoidance of doubt provision.
Exactly.
Yeah.
I was going to show the court the passage quoted by the Court of Appeal from the St Albans case. The St Albans case is also in the judgment, but the relevant... in the judgment, in the bundle.
Is it the one we looked at? We looked at the St Albans case. The same one or a different one?
No, it's the same one. It's
Right.
the same one. And the relevant passage... forgive me, it's not the St Albans case. I'm taking you to the wrong reference. If you just give me a moment, please. It's St Alban and Attorney General, and the relevant passage is in the Court of Appeal's judgment at page 180 of the bundle. Paragraph 18. The word deemed is used a great deal in modern legislation. This was said in 1952. Sometimes it is used to impose, for the purpose of a statute, an artificial construction of a word or phrase that would not otherwise prevail. Sometimes it is used to put beyond doubt a particular construction that might otherwise be uncertain. Sometimes it is used to give a comprehensive description that includes what is obvious, what is uncertain, and what is impossible. Well, there's nothing impossible here, but it's, in our respectful submission, a combination of the obvious and the uncertain. And of course, I'm reminded that, as I've already explained, subcontracting can indeed be informal. So it may not actually involve a formal contract. Again, this works against uncertainty. Now, I wanted, against that background, to talk about two submissions the respondents make which go to construction before I turn to our submissions on public protection. And these are both submissions advanced in an effort to distinguish this case from the position in London, mindful of the court's dictum in Aslam, no doubt. And the first is whether the licensed activity of an operator extends to the acceptance of bookings, not merely making arrangements. And Vizu ran this point at first instance and lost. It was not pursued in the Court of Appeal, but we think it's at least possible that D.E.L.T.A have resurrected it. We're not sure. Mr. Colvin will no doubt confirm. But we can see why it's attractive for D.E.L.T.A to run this argument, because acceptance is so obviously inherently contractual. But if it's right, it would be a remarkable gap in the triple lock. The very act of entering into the arrangement would be unregulated. And I'm going to show the court, if I may quickly, 4 reasons why this is obviously wrong, just in case the argument is made. And this
is an argument that seems to be at least latent in some parts of the case, that the words provision for makes a difference.
Yes. That it's
so to understand that theory, if it were carried through, it would mean that actually when you answer the phone and agree to send a car, you're not accepting a booking there. That would be the implication.
That's the kind of argument that might be there, but as my...
You don't actually accept the booking until the driver turns up. You're just providing for that to happen.
Exactly. But I just want to show you why we submit. It's clear that the acceptance of a booking, not just the making arrangements for acceptance, are part of the regulated function. And if we could turn first to page 386, please. These are provisions you've already seen, so I can take this quickly.
So, page number again, please.
386 in the main bundle. (46.1d). This is the triple lock. No person shall, in a controlled district, operate any vehicle as a private hire vehicle without having a licence. So, on any view, it is only lawful for a licensed operator to perform the functions of operator. On the respondent's case, or it may be that would at least involve making arrangements for the invitation and acceptance of bookings. Those are the antecedent steps to accepting. So only a person who has taken at least some of these antecedent steps can accept a booking. That person is an operator. And moving on just quickly, please, if I can, 55A at page 406. This is subcontracting again. Page 406. A person licensed under section 55 who has, in a controlled district, accepted a booking may arrange subcontracting. Now, of course, this doesn't say in terms, only an operator can accept a booking. But of course, only a licensed operator can make arrangements to accept bookings. But if someone other than a licensed operator could accept a booking, section 55A wouldn't apply. And as a result, the Act would not regulate subcontracting by that other person. In our submission, there is no reason why Parliament would have created such a gap in the regime of protection. And then thirdly and fourthly, section 56(1), page 409. For the purposes of this Act, every contract for hire of a private hire vehicle shall be deemed to be made with the operator who accepted the booking. And then finally, 56(2), which talks about the obligation of records that apply in the third line to every booking of a private hire vehicle invited or accepted by him. Acceptance is part of the regulated function. The second point I want to respond to, the respondents definitely make. And this relates to provision of the PHV. Uber's case, as you appreciate, is that the operator must contract to supply the transport service. That service is delivered using a PHV, but we agree, as I've already said, the operator need not provide the PHV personally. They can subcontract. But even when they subcontract, what they must do is make arrangements to fulfil the booking. Can I show you what Visu says about this, please, in its case? And this is in the core documents bundle, tab 4 at 118, or in the main bundle at 159. This is paragraph 39 of Visu's case. The 1976 Act is unconcerned with who provides the vehicle. And when they say vehicle, they mean PHV, the composite of vehicle and driver, as we understand it. A, provision of a private hire vehicle is not a regulated activity. C, a licensed operator who accepts a booking for a private hire vehicle may ask any person to provide the vehicle. And then they cite the Bromsgrove case, which I'm going to take you to in a moment, as authority supporting this, where Mr. Justice Dyson said, the definition of operate focuses on arrangements pursuant to which a private hire vehicle is provided, not the provision of the vehicle itself. The word operate is not to be equated with or taken as including the providing of the vehicle, but refers to the antecedent arrangements. And then finally at 45, paragraph 45, at the end, the antecedent arrangements, which comprise the definition of operate, do not include hiring out a PHV. So they say, because an operator does not have to provide the vehicle, it is not concerned with the hiring. Our case is that that is in fact to conflate two different things. But if Visu is right, there is a striking gap in the protection of the Act. Apparently, any person can provide the vehicle, fit or proper or not. But it makes this submission to try to drive a wedge between the function of the operator and the provision of transport. As you've seen, the focus of this submission is the case of Bromsgrove and Powers, It's the one other authority I intend to take the court to. In our submission, the respondents have both misconstrued it and overstated it. It is powerfully supportive of Uber's case. And the judgment is at page 870. And I am going to need to show you the facts and some of the reasoning, but it is short. And you'll see at 870 it was decided by Mr. Justice Dyson, as he then was, in 1998. And the date is significant because it predates the deregulation of subcontracting. And the facts were that Mr. Powers was an operator in Bromsgrove of a business called B.E.L.T. Green Cars. But you'll see at little 2 in the first substantive paragraph, B.E.L.T. Green Cars did not operate any private hire vehicles or drivers licensed by the council Bromsgrove. He applied for renewal of his operator's licence. The council refused. The effect of Mr. Justice Dyson's judgment is they were right to do so, just to get to the conclusion. But the application for renewal, he was informed by letter of the reasons. At all material times, Mr. Powers and his wife were in partnership in the neighbouring district of Stratford-on-Avon under the name of Chauffeur Express. They held a private hire operator's licence issued by Stratford, and then at little 8, Chauffeur Express employed 5 drivers in Stratford. And then bookings by B.E.L.T. Green Cars for the hire were invited and accepted by Mr. Powers within Bromsgrove. All such bookings were in fact subcontracted principally to Chauffeur Express in Stratford, but also to 2 other operators. Mr. Powers subcontracted, then it says at 10, the council refused Mr. Powers' application for renewal of his licence on the grounds he was not operating in accordance with the Act because he was only permitted under such a licence to make use of vehicles and drivers licensed in the same district. And that was indeed the law as it then stood. And indeed, Bromsgrove is one of the authorities that makes that good. There are others in the bundle.
And which led to the deregulation.
Exactly, my lord.
Because, I mean, viewed retrospectively, it all seems awfully restrictive.
Exactly. That's exactly it. And what I want to do is show you a little bit of the argument on page 873, because in fact Mr. Justice Dyson specifically endorses this argument. And we will see at the top of 873, the first substantive paragraph. Mr. McGuinness, on behalf of the council, submits 1. By inviting and accepting bookings in the controlled district of Bromsgrove and arranging for other operators as subcontractors to fulfil those bookings for his customers, Mr. Powers was operating as private hire vehicles within the meaning of section 46. And then it makes the point on a true construction as explained in D.E.L.T.A, private hire operators are required to make use only of vehicles and drivers licensed by the council. And this first submission is the one that Mr. Justice Dyson endorses. And then in the next paragraph, it says, Mr. McGuinness's argument in relation to his first submission is very simple. He says that the definition of the word operate focuses on the arrangements pursuant to which a private hire vehicle is provided, not the provision of the vehicle itself. It is common ground that the word operate is not to be equated with or taken as including the providing of the vehicle, but refers to the antecedent arrangements. That is clearly right. That is the passage that you saw that Visu rely on. And then you'll see 2 paragraphs. In the next paragraph, he cites various authorities for that proposition. But then at the end of that paragraph, it is also common ground. There is no prohibition on an operator subcontracting providing of a vehicle to another operator. Such an arrangement is explicitly acknowledged and sanctioned by section 56(1) and 2. So pausing there is the statutory permission to subcontract pre-2015.
Within a district?
Within a district, exactly, my lord, exactly. But subcontracting was permitted by the Act as originally adopted. That's the important point. And then just for context, we see what Ms. Parry's argument was on behalf of Mr. Powers, that because the vehicles and drivers were not provided by Mr. Powers, but a subcontracting operator, he did not operate. That was the submission that failed. We will see at the bottom of the page another observation of Mr. Justice Dyson that is important. The draftsman was alive to the concept of providing vehicles. Section 56(1) is of importance here, as it shows the draftsman plainly understood an operator might or might not himself provide the vehicle. In view of this, it seems to me Parliament deliberately decided to make liability of an operator not dependent on whether he provided the vehicle. So he rejected Miss Parry's submission, and then in the fourth paragraph down, in a paragraph beginning the only words he has inserted, which is part of the argument we're not concerned with, in the last 4 lines he says, I am satisfied that Mr. McGuinness's first submission is correct. The language of section 46(1)(e) is clear and cannot bear the meaning for which Miss Parry contends. And just to remind you what that first submission was, it's on 873. By inviting and accepting bookings and arranging for other operators as his subcontractors to fulfil those bookings, Mr. Parry was operating. Oops.
But I mean, he wasn't there dealing with the issue with which we're dealing, namely whether that was done by way of a contract.
Oh, no, absolutely.
Or anything of that kind.
No, but what matters, my lord, for me...
It was simply that it was within the operation function.
Exactly. But the reason I take your lordships and your ladyship to that case is it's the Visu's case that anything to do with fulfilling the booking is no part of the operator's function, precisely because of what is said in Bromsgrove. But our submission is it's much narrower than that. Bromsgrove shows that both acceptance of bookings and making arrangements for their fulfilment are functions of the operator. The operator need not fulfill that booking personally. It may use a subcontractor. But this is all inconsistent with the respondent's case, that an operator has no responsibility for the performance of the booking. I absolutely accept my Lord Briggs's point that this itself doesn't answer the question of whether that fulfilment has to be pursuant to a contract, but it does show in my submission that the respondent's case is very greatly overstated where they try to cleave the operator away from performance of the booking. Those are my submissions on construction before I now turn to public protection.
What is providing a private hire vehicle?
Sorry, my Lord, I didn't get...
What is the concept of providing a public hire vehicle? How does that fit into the regulatory scheme in your analysis?
Well, providing the vehicle can be done either by the operator himself or by a subcontractor. It is our submission only an operator can provide the vehicle. By vehicle, I mean PHV, the composite.
Yes, that's what we're talking about.
But why can't the owner provide the vehicle?
Well, the owner could do.
The owner is a regulated person under the triple lock, isn't he? The person who owns the vehicle.
Yes, so...
why isn't the triple lock requirement satisfied by treating the owner as responsible for the provision of the vehicle?
Well, it's just the terms of the Act, my Lord, is the answer. So I rely on Section 55A and I rely on Bromsgrove as the answer to that question.
But so are you saying that the concept of operating does embrace providing a vehicle?
No, I'm fully prepared to accept that an operator, if I go back to the language of Mr. Justice Dyson, an operator might or might not himself provide the vehicle. His obligation is to make arrangements to fulfil the booking. He can do it with his own vehicle, for example, an employee of his, or he can subcontract. But it is the operator's function to make arrangements so that the car comes at 9 a.m. to take the passenger to the airport. It is not left at large in the way that the respondents say.
But then the person who is providing the vehicle might not be regulated.
Well, in my submission, the person providing the vehicle has to be an operator. And we take that from 55A. Would it be helpful to go back to that?
Sorry, I thought you just said the operator might or might not provide.
Exactly.
Yes, sorry, I did. So,
which is it?
But may I just show you what the passage that I was alluding to? It's in Bromsgrove, and it's page 873. And it is about subcontracting. It's the last paragraph of Bromsgrove, of that page, I'm so sorry. The draftsman was alive to the concept of providing vehicles. Section 56.1 is of importance here, since it shows the draftsman plainly understood an operator might or might not himself provide the vehicle, subcontracting.
Well,
Doesn't say that.
Well,
It just says provide the vehicle.
Indeed, but this is in the context of an argument about subcontracting. And if I show you now 56...
But you need to include the next. We need to look at that in the context of where Mr. Justice Dyson is going.
Yes.
Which is to say, it's clear, therefore, that providing the vehicle isn't the touchstone for incurring the regulatory liabilities of an operator.
Yes, exactly so. Exactly so, my lord. And it is our submission only an operator can provide the vehicle, and we take that from 55A, and indeed from its precursor, from the original provision 56.1 and 2. May I take you back to that in the hope of giving a better answer? So if we go back to 55A, which is 406, a person licensed under Section 55 who has, in a controlled district, accepted a booking for a private hire vehicle may arrange for another person to provide a vehicle to carry it out. And A, B and C are all operators. D allows for Scotland, where operators are only required if there are 4 or more cars. So, admittedly, not always in Scotland. So that makes clear that the booking has to be fulfilled either by the original operator or by another operator. 56, we would submit, also makes clear only an operator can contract, even before this section. And we go to 409. The court has already seen these provisions, of course. 56.1, every contract for hire shall be deemed to be made with the operator who accepted the booking, whether or not he provided the vehicle. That doesn't tell us who else can provide the vehicle. But then it's 56.2, which is the very important record-keeping function, which says that bookings, the particulars of each booking, picking up at line 3, invited or accepted by him, whether by accepting the same from the hirer or undertaking it at the request of another operator, must be taken. But if in fact someone else altogether different and completely unregulated could fulfil the booking, that would be a glaring hole in the scheme of regulation. That's why we say it's wrong. And as Mr. Justice Dyson said, these provisions actually authorise subcontracting between operators.
So you say, do you, that when you accept a booking, you must either, you're agreeing either to provide a vehicle to carry it out yourself or to arrange for another operator to do so?
Yes, or to use the word that was endorsed by Mr. Justice Dyson, to fulfil the booking. That can be with your own vehicles, it can be through a subcontract. So, yes.
But only a regulated person can do it.
Yes. May I turn now to public protection?
And so on the... Is that necessarily constitute a contract of hire?
Does which, my lord?
Entering into that arrangement. If I agree to arrange for another operator to provide a vehicle, am I entering into a contract for the hire of a vehicle?
What you're agreeing with the hirer is to provide a PHV service at 9 o'clock to go to the airport. How you execute that is a matter for the operator. It is common ground that there can be subcontracting and subcontracting can be concealed. So all that is agreed is, yes, a PHV will turn up at 9 o'clock to take you to the airport. Or it may just be turn up at 9 o'clock with a destination to be decided. That's the point my friends make. We don't dissent. But that's the contractual part. Fulfilment is, if you like, a second-order matter, and fulfilment can be through subcontracting. but the first operator, ABC Cars, has taken on that burden.
And you say that it amounts to entering into a contract for hire?
Yes, we do.
Albeit the terms may be variable.
The terms may be variable, but the terms are variable, but at least are ascertainable in advance. In other words, when the customer makes the booking with ABC Cars, if they are interested, they can look and see what terms ABC Cars has.
Yeah. Well, they might agree the price at that time, or they might not. And so
They might at that time, or they might not. There might be an estimate, there might be a fixed price, there may even be a meter. But PHVs allow the potential to agree that in advance. So with that, I was going to turn to public protection again. And of course, as the court appreciates, one of the issues here is how wide is the scope of this? Is it just passenger safety in the vehicle? And the Court of Appeals said Uber's argument relied on an over-expansive view of passenger safety. And it said protection of the passenger was ensured by suitability of the vehicle and the fitness and competence of the driver. And those are, of course, two very important elements of the triple lock. But so too is the role of the operator. Yeah. And the operator's role, obviously, as is clear, precedes the getting into the vehicle by the passenger. And I reiterate the point I made in answer to Lord Stephen's question. It is not our case that because these customer benefits would be desirable, the Act should be interpreted to give effect to them. Our case is the requirement to contract is inherent in the language of the Act, and that itself furthers the objectives of customer safety. But why? I want to turn to a why now. The very essence of a PHV service is it can be pre-booked. The hirer can specify the PHV to arrive at a particular place and time, and indeed, depending on the PHV operator, may be able to specify the fare. A customer has made a choice to use that service rather than a hackney carriage, because of course it is more certain than hoping to hail a hackney carriage when you need it to get to the airport. And of course, a hackney carriage, the fare will be metered. So there is inevitable uncertainty as to how much it would be. A contract for hire gives clarity and certainty as to these matters. And in our case, we summarised 4 public protection benefits, all of which I've anticipated to some degree in the submissions I've already made. So I'll make them shortly. First, on Uber's case, a contract of hire arises immediately on acceptance of the booking. It cannot be deferred to the moment the car arrives, if the car ever does. On the respondent's case, there is no contract, no obligation on the operator to ensure a car turns up. And of course, on their case, the deeming provision will not come into effect, again, until the car turns up. Secondly, there is transparency about who the contract is with. The hirer knows who is legally responsible and can establish on what terms. It cannot be said later the contract was with a driver or with an unknown third-party subcontractor. The third benefit is indefeasibility. An operator cannot contract out of a contract required by regulation, even though we've seen Visu's terms seek to do exactly that. And the fourth benefit is enforcement. On Uber's case, from the time the booking is accepted, the hirer has a contractual remedy against the operator on the terms of the operator that it chose. Now, the respondents say that kind of remedy is irrelevant here to the scheme of public protection. But of course, even on their case, Section 56(1) makes clear Parliament considered contractual recourse against the operator to be part of the scheme of public protection. There's no doubt about its value. The issue is when it arises and the extent to which an operator can effectively contract out of it. Now, absolutely, it is right that there can be enforcement by the district authority, but it's important to see what that enforcement actually looks like. Could we turn now to page 420? This is a section I haven't shown you. Section 62 This is the power of enforcement from the public authority. Notwithstanding anything in this Act, a district council may suspend or revoke or refuse to renew an operator's licence on any of the following grounds. A, any offence or non-compliance with the provisions of the Act. Or B, any conduct which appears to render him unfit. So suspend, revoke and refuse are the remedies, including if in fact, as Sefton has done, the local authority imposes a condition which is relevant to contractual performance. It can't just impose further conditions as it goes along. It can only do that on renewal of the licence. And of course, we accept that at a certain point of critical mass of complaints, say, a district council may indeed decide to take one of these measures. But they're obviously very severe measures. I'm sure they're not taken lightly. They're very, very far from being an individual remedy for individual failures. And as the divisional court put it in the London case, the existence of such contractual rights is itself a powerful incentive to perform properly. Now, against that background, I want to turn to what the contract might or might not provide. My Lord.
Well, I really wonder who's going to enforce the contract and how?
Well, of course, any consumer contract of relatively small value is unlikely to be the subject of litigation, but the law recognises that there is obviously value in a contractual right, even at small sums of money. Indeed, this regulatory scheme in section 56(1) says there is importance in there being a contract with the operator. So it doesn't have to be the case that it would be commercially viable litigation for it to have any value. As we put it in our case, the existence of the contract has a disciplining effect. It is also a device that gives clarity.
I thought the existence of a regulatory scheme has a much greater effect, and perhaps also simply a desire to protect reputation. You know, the word gets around if ABC is an unreliable operator and will leave you, standing on the pavement on a wet Saturday night, unable to get home.
Well, my Lord, I respectfully agree, all of that has value, but so too does the individual contract. Well,
I suppose what you're really going to do, if you're going to do anything as the customer, and you very aggrieved, is you might call up the council and make a complaint about the
you may do.
About the operator. And I suppose it might make a difference. You would say that you can say, well, they failed to perform their contract with me, rather than simply that they failed to carry out something which they never agreed to do.
Well, you'd be quite a loyally customer. I mean, your main complaint would be, I made a booking and it didn't turn up.
Yeah.
Indeed.
And as I understand the bookkeeping obligations on the operator, the council can always then go and check what the operator's record is in terms of fulfilling or not fulfilling bookings.
Well, I respectfully accept all of that. I put it in the category of public enforcement. What a contract does as well is give you the ability to pursue private enforcement. It may not be in the courts, but being able to say to the operator, you have contracted to do this, you have not performed. The terms of the contract may well govern exactly what those rights are, including the right of the customer to cancel, the right of the operator to cancel in the case of, say, unruly behaviour by the customer. It provides clarity and precision as to the rights and obligations between the parties. That's the value of it. Of course, you can also complain to the council. Depending on their priorities, they may well eventually take action. Now, I want to be clear, though, we're not saying that every contract of hire has to be strict liability on the part of the operator. Of course, there may be limitations of liability, just as there are in Uber's case, which I'm going to come to very shortly. But the law of contract and the common law imposes controls on the extent to which a liability can be limited in a consumer contract. And of course, the Consumer Rights Act 2015 provides that unfair terms are not binding on a consumer, and a term is unfair if it causes a significant imbalance in the rights between the parties. And in particular, the courts have implied terms into contracts requiring notice before there can be termination. So it's not simply the case that an operator is free to emasculate a contract of hire through terms. But as Uber's own terms have been criticised by D.E.L.T.A, I want to take you to them now, if I may. And they are in the bundle. So I'm going to give you the precise page reference, if you just give me a moment. At 2154, these are Uber's passenger terms. And they regulate a range of matters between the parties. But it's the exclusion of liability that is highlighted. And you'll see at 2158, for example, there are provisions dealing with cancellation and termination. And then at 9, there is limitation of liability. 9.1, nothing limits or excludes any liability that cannot be legally excluded, including death, personal injury, fraud, etc. And then at 9.2, there is an exclusion of liability for consequential losses. And then at 20.1, there is the clause that is the focus of D.E.L.T.A's submissions. That's at 2162. And here we see clarity in Uber's arrangements. A request for a booking constitutes an offer by you.
Sorry, which clause are you reading?
2162 20.1. A request for a booking constitutes an offer by you to purchase Uber transportation services in accordance with these terms. This booking request will set out the main characteristics of the Uber transport services, including pick-up and drop-off. Your offer shall only be accepted when Uber issues written confirmation. And then it says, just ... at which point and on which date and time a contract for Uber transportation services to which the booking shall relate shall come into existence. So you know who it is with, when it arises, and on what terms. There is no obligation on us to accept a booking, and it may be declined for any reason. That's obviously prior to acceptance. And then, if a driver becomes unavailable after we have provided you with written confirmation of the contract, we will endeavour to find you another driver for your booking. Where an alternative driver cannot be found, we reserve the right to terminate without compensation. So
you're in the same position as you would be without a contract.
Yeah.
At that moment, you would be.
Yeah.
But what this contract
having waited for this car to turn up.
My lady, I fully accept that. But what the contract says is, we are going to provide the service, but if, in fact, the driver then becomes unavailable and we cannot find another, then yes. But in my respectful submission, that is a vast improvement on the Respondents' case, which just says, you have no contract, you have no rights. And of course, the local authority can police these terms if they think that they are unsatisfactory. So even though this is a target of criticism, in my respectful submission, this is an entirely reasonable balance of rights and responsibilities. It's not strict liability, but on the other hand, it provides meaningful safeguards and clarity to the customer. I was then going to address you briefly, I'm starting to run out of time, I have a little, on necessary implication. There's one thing that the Court of Appeal said was that Uber's case depended on showing that the contract arose by necessary implication, not mere implication. And if it's right, then the implication has to be compellingly clear, according to a line of case law. As you will anticipate, we say it is compellingly clear, but we also say this is not actually the right legal test. And that is made clear by this court's judgment in 4 Women's Scotland. May I turn that up, please? And the relevant passage is at page 932. And of course, as Visu rightly says, the context could not be more different. But nevertheless, the observations made here are of...
But it's more than the context. That was looking at whether the disapplication in 9.3 applied.
Yes, absolutely. But what the court did, as of course your ladyship will know better than I, is look at this line of cases about necessary implication. May I take you to, actually useful to start at 931, which is paragraph 101. We see force in Mr. Cooper's argument that the carve-out in section 9.3 is not limited to express statutory provision or to circumstances where there is a necessary implication. The necessary implication test was discussed in Morgan Grenfell. That case concerned the abrogation of an important common law right, namely legal professional privilege. And then at 102, the court refers to the case of Sims, which also involved an important right of prisoners to correspond. And what the court said is the stringency of the necessary implication test is not appropriate when considering the application of section 9.3. The principle of legality described by Lord Hoffman in Sims is not engaged here. This is not a case where the court is being asked to override a basic tenet of the common law or constitutional rights.
I mean, but in this case, what you're seeking to override is a basic common law right, whether or not to provide a service in a way that involves a contractual obligation, or in a way that doesn't involve a contractual obligation, or which involves some contractual obligation other than the full provision of the vehicle for the whole of the hire. And I suppose one can label it freedom of contract.
Well, indeed, that is what the respondents do say, my lord. Well, in my respectful submission, that's very far from abrogating freedom of expression of prisoners or anything of that kind. It's entirely anodyne for commercial regulation to impact upon freedom of contract in that sense. It's just, indeed...
Well, it's perfectly all right for it to be done expressly. The question is what test is to be applied if it's going to be done by pure implication.
Well, indeed, but decades...
If you're wrong on if there isn't an express provision.
Yes, well, there's been decades of litigation on the precise meaning of different regulatory obligations in the field of commercial regulation, my lord. I don't accept that all of them have to meet the test of necessary implication. But if it does, we're content to say...
Well, you say it's necessary. No, I understand that.
We say it is. That was all I was going to say on that topic. And I was going to turn to London, the position in London. Now, of course, as you appreciate, Uber's submissions seek to achieve consistency with London. And there, the divisional court held that acceptance of a booking by an operator in London does create a contract to provide transportation services, and the operator is party to it as principal. And it did so in reliance on the obiter dicta of this court in Aslam, and its ruling was expressed in general terms. And it might be useful just to see that. It's at page 1463. So sorry, 1474. And this is just the... We'll see at paragraph 28, the 1998 Act plainly contemplates acceptance of a booking by an operator will create a contract between the operator and the passenger. And furthermore, this will be a contract by which the operator undertakes an obligation as principal to provide the transportation service, that is to say, to provide a vehicle and driver to convey the passenger to the agreed destination. And then at the very last page of the judgment, actually best picked up at the bottom of 1481, they say, under disposal, we have concluded, perhaps not surprisingly, that the Supreme Court meant what it said in Uber Aslam, and we must follow the decision of this court in another matter. Accordingly, we grant a declaration that in order to operate lawfully under the Private Hire Vehicles London Act, a licensed operator who accepts a booking from a passenger is required to enter as principal into the contractual obligation with the passenger to provide the journey which is the subject of the booking. And, of course, these proceedings seek a similar declaration, the practical effect of that judgment of the divisional courts was to put an end to the agency model in London. But importantly, neither the respondents or indeed the courts below have suggested that there is any error in either the observations in Aslam or indeed in the divisional court's judgment that I've just shown you. The respondent's strategy in this case is instead to distinguish the London regime. And there's a lot of detailed submissions on this in the written cases, but our short point is that the differences are immaterial. The London Act is not identical to the 1976 Act. That's unsurprising. By the time it was enacted, there was the experience of 21 years of operation of the 1976 Act. In certain respects, it is clearer. That is the 1998 Act. But our submission is it targets exactly the same mischief and it achieves the same result. But what I do want to do is highlight two differences of at least potential relevance that feature in the dicta of this court in Aslam. Could we go to that, please? It's at page 1595. And this is in the judgment of my Lord Legate that the rest of the court agreed with. Paragraph 47. References in the Private Hire Vehicles London Act to acceptance of a private hire booking are reasonably understood to connote acceptance, personally and not merely for someone else, of a contractual obligation to carry out the booking and provide a vehicle for that purpose. And that is why, as we understand my friends' tactics, they have focused on these words acceptance and provision of a vehicle, seeking to distinguish the London Act. But I've already shown the court why these are distinctions without a difference. Under the 1976 Act, the regulated function of operator extends to acceptance of a booking. And as to the provision of a vehicle, an operator under 1976 Act need not provide a vehicle personally, but if it doesn't, it must make arrangements to fulfil the booking with a subcontractor. And that position is exactly the same in London. And that was the one part of the London Act I'd like to show you. This now is at page 503, please. In fact, while we're here, I'll show you two parts. Page 503, starting at 1.1b, is the definition of operator. Operator means a person who makes provision for the invitation or acceptance of, or who accepts private hire bookings. You already have my submissions. That is a distinction without a difference. And then if we turn on, please, to page 507, Section 4, 2. A London PHV operator shall secure any vehicle which is provided by him for carrying out a private hire vehicle booking accepted by him is a licensed vehicle. So those words provided by him are separate, are distinct to the 1976 Act. But this is a distinction without a difference, because if we turn on to page 508, we see in section 5 a subcontracting provision that has a high degree of similarity to the 1976 Act as amended. In other words, section 55A. A London PHV operator who has in London accepted a private hire booking may not arrange for another operator to carry out that booking as subcontractor unless one of A, B or C. A London operator a 1976 Act operator or the booking is in Scotland. So just like the 1976 Act, in London, an operator may provide the vehicle themselves or may do so through a subcontract. And then for completeness, there is section 5.5, which has similarity to 56.1. For the avoidance of doubt, which is how we say we read 56.1, a contract for hire between a person who made a private hire booking at an operating centre in London and the London PHV operator who accepts the booking remains in force despite the making of arrangements by that operator for another contractor to provide a vehicle to carry out that booking as a subcontractor. The drafting has been improved since section 56.1. The import of it is the same. That's why we respectfully submit that attempts to distinguish the London Act are of no avail. And then finally, 1223, I was just going to come back to the Maxwell Stamp report and explain how and why we rely on it. We don't say it has the status of a ministerial statement in Hansard. We don't rely on Pepper and Hart. And in fact, the passage of Hansard we have relied on, we no longer do so in light of this court's judgment in Darnwall. That, we accept, is of no assistance. But the Maxwell Stamp report is of assistance by way of historical background. That's how Mrs. Justice Foster found it to be of assistance in paragraph 78 of her judgment. And that, just for the transcript, is KDB 8171. And D.E.L.T.A, at least, also relies on Maxwell Stamp for that purpose. So we don't say it's a direct tool of interpretation, but what it does do is explain the mischief against which the 1976 Act was adopted, and in some respects it is uncannily similar. And of course, between Maxwell Stamp and the 1976 Act were two other acts. There was a Liverpool Act in 1972 and a Plymouth Act in 1975. They also reflect its recommendations. I accept it does not match in every single respect, but the gravamen of it is as reflected in 1976 and as reflected in our submissions. We set out the relevant parts in our written case. I don't propose to go through them unless you'd find it to be of assistance. So unless I can assist further, those are the submissions for the appellant.
You have, whereabouts do we find the declaration which you're seeking to obtain in these proceedings?
It's paragraph 115 of our written case, which is in the core volume, at page 93. If it would be helpful, I'll find the key document.
Yes, please.
As well. 52 of the key documents bundle.
The 93 is the general bundle.
Yes.
Thank you.
So you're seeking a declaration that an operator accepts a private hire booking to contract as principal with the person who made that booking to fulfil the booking. And that is, the person who made the booking may be an agent for somebody else.
Well, the intended sense of it is the person who is principal. Of course, this court has the power to grant a declaration in slightly different terms if it thinks fit. But it is not our intention that the counterparty to the contract is the hotel receptionist.
Thank you very much, Mr. Ward.
Thank you.
So, Ms. Corbyn.
May it please the Court, I'm going to summarise our case, then I'm going to describe the legislative context, and then deal with the key sections in the Act. And then I'm going to touch very lightly on Maxwell Stamp, London and the Declaration.
And can I ask, are you going to be addressing us on behalf of the respondents as a whole, or are we hearing also from Mr. Gourier?
My Lords and my Lady, the scheme is we have 2 hours. I'm going to try and confine my submissions to an hour.
Yes.
My arrangement with Mr. Gourier, using his words, is he's going to be the wicket keeper. So all the balls which get past me, he's going to catch.
Right. Okay. And if I'm the umpire, am I to keep you to the hour?
Mr. Gourier has generously allowed me to stray over if need be. But I hope to try and stay within the hour. That is my intention. Lords, the summary is this. I submit the Court of Appeal was right for the reasons which it gave, and we certainly agree with Lord Briggs that the searches for statutory language, which includes the obligation on which the appellant relies. The 1976 Act protects the safety of the public using PHVs by requiring the vehicle, the driver and the operator to have and comply with their respective licences, overseen by a common licensing authority, so resolving the long-standing lacuna that hirings resulting from plying were regulated, while those resulting from booking weren't. The Act defines the activities which require a licence, it sets threshold criteria for obtaining the licence, and imposes express requirements and prohibitions on licensees. And as you'd expect of licensing legislation, the Act makes sure that the vehicle meets local standards and that the driver and the operator are fit and proper. But there is no definition of the licensable activity, no threshold criteria, and no licence requirements or prohibition in relation to contracting. In short, the Act doesn't require the operator to contract as principal with the person making the booking at the point of booking. Rather, the Act specifically and expressly deals with contracting by deeming that the contract of hire is with the operator who accepted the booking. The language of the Act reveals both the parliamentary intention that the operator should be fixed with contractual responsibility and the mechanism by which that is achieved, namely deeming. And we say that is in full accordance with the principles regarding deeming adumbrated by Lord Briggs in the case of Fowler, which is summarised at paragraph 21 of the Court of Appeal judgment. Had Parliament intended to require the operator to contract as principal in the real world, it wouldn't have deemed that he does so. By the deeming provision, Parliament gave contractual recourse against the operator without needing to interfere in the myriad types of contractual arrangements which occur and have always occurred in practice. So, for example, if a contract is entered into with a driver, Section 56 gives remedies against the operator for breach. And as such, we say there's no room for Uber's quadruple implication that only the operator may contract, that it must do so as principal, that it must do so with the person making the booking, and that it must do so at the moment of booking. Focusing, as we must, on the words used by Parliament, Uber's case that the statute impliedly requires all of that, whilst expressly making a deeming provision to the same end, is untenable. Uber's supplementary suggestion that unless the operator is required to contract at the point of booking, the customer may be unprotected if no driver turns up is easily answered. Were this an issue, it is resolved by the licensing regime and not by implying statutory requirements, particularly in the absence of language directly supporting the implication.
In relation to the deeming provision, I think it's your case, that is a real contract in the real world.
And we've made that absolutely clear. It's a real contract. The operator is fixed with liability, and that allows for all the multiplicity of contracting arrangements to be scooped up. The operator bears the burden.
And
You say it allows for all the multiplicity to be scooped up, but it's a contract of hire that you're on the hook for.
Absolutely.
Yeah.
Absolutely. And there's no question, and we've made this absolutely clear, we're not trying to slide out of this.
No, it's just a question of timing on your case.
It's just timing. I mean, the customer getting
that may be important, but that is what you say.
Into a Hackney has a hire, the customer getting into a PHV has a hire. There's no question at all, there is a contract of hire when the customer gets into the vehicle.
Well, just before we leave that, then, the Court of Appeal, as I understand it, said that this deeming provision was for the regulatory purposes of the Act, and that it wasn't a contract in the real world. But perhaps I misunderstood.
I think, I mean, I can see how Uber have put it. One needs to, and I'm going to try not to take you to documents, because I know you've read them. What they were trying to say was that the operator isn't required to enter into a contract in the real world, but there is created a statutory fiction for the purposes of this legislation. And what one then gets from Marshall and also from Fowler is that one doesn't let one's minds boggle at the consequences of the fiction, which is that there is a contractual liability.
Section 56 starts with the words, for the purposes of this part. This
Yes.
part is a regulatory function.
Yes.
And so what is the regulatory function which requires there to be a contract?
Yes, it is the way we read for the purpose of this part, Parliament was saying it doesn't mean that the operator has to enter into a contract in a private sense in the real world. It doesn't mean that for tax purposes or employment purposes, but it does mean that under this legislation, the operator is deemed to contract. So the consequence of that, the term used by Parliament is contract. The consequence of that is that under this Act, the customer, who is the party protected by the legislation, has recourse. It doesn't apply for other schemes, for tax.
So the regulatory purpose is the recourse of the customer, is that right?
Indeed. Indeed.
Against the operator?
Against the operator, yes. And we don't seek to shy away from that one bit. In the real world, there may be a contract, but in the world created by Section 56(1), the operator bears the contractual responsibility. That's how this works.
But do you say that the driver is authorised under the Act to provide a vehicle to carry out the booking?
Yes. I mean,
just by virtue of having the driver's permission?
Well, absolutely. Otherwise, the Act would not be workable. We spent a lot of time analysing this case through the lens of subcontracting. But can we just get back to a real world, a 1976 world in which people didn't have mobile phones and apps uploaded with their debit cards with the terms set out on their mobile phones? This was somebody calling up from the hairdresser saying, can I speak to Jim, please? Yes. Can you send a card to the hairdresser, please? And that's it. And Jim, taking the booking, entering it into the record, says, yes, accepted your booking, Beryl. We'll have someone with you in 5 minutes. They've accepted the booking. When the driver gets there, under my client's arrangement, the driver says, where are you going? She says, I'm going home. He says, oh, that'll be a tenner. She says, that's marvellous. The driver has entered into a contract under which the operator is liable. So the booking could be a contract, and Mr. Ward gave an example of someone needing to get to Manchester Airport tomorrow and booking to book the car for £100 to get him to the contract. But it needn't be a contract. It's all a question of what the arrangement is at the point of booking. So a booking can be a contract, or it can be merely a reservation of a vehicle to turn up at a time and place and wait instructions. And that's all that Parliament was saying in 1976.
Well, if you have a reservation of a vehicle to turn up at a certain time and place,
yes,
and you accept that obligation, isn't that a contract?
You could, Lord, we do not interpret it in that way as a contract, but it doesn't harm our case for it to be interpreted in that way. It's a reservation in the sense that we are going to do our best to get a driver to you at time and place.
Well, isn't that undertaking some form of obligation? It's pretty hard to see how it doesn't connote at least agreeing to do something.
Yes, of course. We've no problem with the concept that the operator who takes a booking can't just wash his hands of the whole thing. And if he doesn't do what he said he's going to do, if he goes off to lunch and doesn't send a car, then there's going to be a consequence. The customer is going to say, I was standing around.
Well, isn't that a contract?
I beg your pardon?
Isn't that a contract? He's agreeing to doing something. Isn't that a contract?
He's agreeing to get a car there at time and place, but the journey, the actual fulfilment of whatever it is that the customer wants to do, it could either be a contract at the point of booking, or it could be a contract at some other time, or with some other party. But the actual contractual obligation, what is it that the customer wants to have done, does not necessarily happen at the point of booking. It doesn't necessarily happen with the operator at that point. So it is a regulatory scheme under which the operator makes provision for the invitation or acceptance of booking, and on booking, the operator is saying, yes, I will, or I will do my best to fulfil that by getting you a driver there at the time and place arranged.
I think if I were booking a taxi to the airport and I was told, well, we'll do our best, I'd be on to a different firm.
Absolutely. Well, we completely agree with that. But in 2017, my client did that 12 million times because it has a reputation that while it's going to do its best, it cannot promise, because what my client does, and this is true of many other operators, what my client does is to say, look, we're not the contracting party, we've got a cadre of drivers, we'll put out the call, we'll try and fulfill this. And the customer says, no, this is really important, I really do need that booking, is free then to go to a company which offers that service of a specific driver or a specific time and place for a specific journey. But the point under this legislation is that these contracts arise in myriad different ways, in myriad different circumstances. In Uber's case, they say, we'll accept a contract to find you a driver. If they can't find a driver, they cancel the contract and they say under their terms there'll be no compensation. In my client's case, it says, phone us, we're a booking platform, we're a best endeavours service, we'll do our level best to find you a driver, but if we can't find you a driver, that's it. And my client's customers, it operates in 6 licensing authority areas over the last 50 years. My client's customers have been very happy to deal on that basis. Because there's no system of private hire which can always guarantee that there's going to be a driver available at the point when you want the driver to be available.
Well, I might have imagined that part of the purpose of the regulation was to ensure that the service provided was a reliable one, so that, for example, young girls trying to get home late at night on a Friday or a Saturday aren't left standing around vulnerable.
Yes, and if they want someone to come specifically at a time and place, then they're free to operate they're free to telephone somebody or contact somebody who will make that promise. What Sefton does, in my client's case, is to include a contract, and it's referred to in the Court of Appeal, a licence condition, and it's referred to in the Court of Appeal judgment, that says the operator who accepts a booking shall use best endeavours to get somebody there at time and place. If it transpired that my client just wasn't operating in that way, that there was a level of complacency about it, then the consequences for that are under the licence. May I come and just deal with the context and purpose of the legislation? The context of the legislation is not in dispute. As you know, since 1846...
Sorry, before leaving that,
yes.
You accept that there is some sort of agreement at the point at which the booking is accepted, and that there is a regulatory purpose, namely having recourse to whatever that some sort of agreement is.
Yes. I mean, whether it's a contractual agreement perhaps doesn't matter that much, but the operator is certainly taking on obligation to do something. They're not sitting there just receiving bookings for the fun of it. What Section 46(1)(e) of the Act contemplates is that there's an operator who himself is responsible for using licensed drivers and licensed vehicles. So the operator has a real function there, takes the booking, makes a record of the booking, and quite clearly it's an instance of that the operator has got to do something to get a licensed vehicle and driver there. But what the Act was not too worried about was whether there was contractual responsibility upon which, say, the customer could sue at that moment in time. So back to the context and purpose, as you know, since 1847.
I do apologise.
So sorry.
The moment in time then is if you pick up 9 people in a private hire vehicle,
Yes.
and at the end of the journey, one of them volunteers to pay for the whole lot.
Yes.
That's the moment of time at which there is not only a real contract, but also a deemed contract. Is that right?
I think we'd put it before that.
No, well, 9 people get into a vehicle.
Yes.
And nobody says anything about who's paying.
Yes.
And when's the contract formed? And with whom?
Under my client's scheme, the driver arrives, and the driver could indeed say, well, which one of you is paying, or whose home will we
Just
go
assuming he
to?
doesn't.
Assuming he doesn't?
Yes. When is the contract formed?
We would say that the contract must be formed at the moment that the driver agrees to take the customers to their destination. At that point, there's a journey, and there'll be, I guess, some sort of implication about price. In the case of my client, it sets maximum prices per mile, and the driver is free to accept smaller amounts per mile.
And presumably, if nothing is said about who's going to pay, then they're all liable jointly to pay, although they may, as it were, agree between each other as to how much each is going to contribute to the fund.
Absolutely. And the whole point of this legislation is it wasn't too fixated on the details of contracting because it had the protection of deeming to ensure that the operator was going to be liable in any case. But
on your case, if I've just understood it, if the driver agrees a fee which is greater than the maximum you permit, the customer has no recourse against the driver. They have to pay what they've agreed to pay. It's simply that the driver has broken his own contract with you. So the customer has no remedy in that situation.
Customer's remedy in that situation, I mean, either the customer may have read what the maximum fares are, and the customer can also ask my client what the maximum will be, and my client will do it. If the customer enters a journey, my client will put an estimated price in for the journey. But the customer is not obliged to enter a destination when the customer books under my client's scheme. The customer can just say, can I have a cab to McDonald's, please? If the driver does something which is high-handed or goes beyond fair practice or whatever, the recourse is, first, the driver's unlikely to be retained by my client any further, and secondly, the customer may go to the licensing authority and say, look, I've just been fleeced. And then it becomes
But I think you accept, thirdly, that because of the deeming provision, being a real-world contract, you say, such dissatisfaction with the driver as amounts to a breach of contract can be visited upon the operator.
Absolutely.
But there would be no breach of contract if the driver had charged more than your maximum
well,
price.
in that theoretical case, I hope that my client has set up the scheme better than that. But if that hadn't happened and the driver suddenly charged £100 for a 2-mile trip, I mean, in reality,
But it points out what seems to be a weakness of the scheme as you interpret it, that the driver, he's regulated for the act of driving, but insofar as he's providing a vehicle for hire, he's providing an unregulated service, you say?
It's regulated by the legislation.
Well, how? What licence does he need for that? He needs none. He just needs his driver's permission.
Yeah, but the driver's licence carries conditions, and if it transpires that the driver is behaving in a dishonest or dishonourable or unethical way, it's certainly within the licensing authority's remit to attach conditions so as to bring the driver under control. And it's also certainly a matter for the licensing authority as to whether that driver is fit and proper at all. And then it's also a question of the reputation of the operator.
Well, of course, you can always say there's reputation, but you don't need the regulation if you're relying on reputation.
I beg pardon?
You don't need a regulatory scheme, then. It just seems surprising that under the regulatory scheme does not, on your case, regulate providing a vehicle to carry out a booking.
Well, I mean, I'm going to come to this when I have the opportunity. The first is that the Act provides what the meaning of the word operate actually is, which is all about the antecedent acts. And secondly, everybody involved in this service is licensed.
But not for the activity that matters here, which is providing the vehicle to carry out the booking. The driver's licensed to drive, the owner of the car is licensed to own a private hire vehicle, and the operator is licensed to accept bookings. But no one is licensed, because you don't need one, to provide a vehicle to carry out the booking, you say.
Because the Act recognises, as I'll demonstrate, that the ways in which vehicles can to be provided, all the different contractual arrangements, all of which were adverted to by Maxwell Stamp in paragraphs 4.61 and 4.62 of the Maxwell Stamp report, Parliament did not interfere with any of those arrangements. It accepted that operators may not actually have any drivers on their books, may simply farm out work to drivers. And the way that Parliament dealt with that, Maxwell Stamp made a whole series of different suggestions, one of which was deeming. Parliament said, all right, deeming is the solution here. So when you've got a contract with a driver, it's imputed to the operator, and the operator bears responsibility. But licensing is a very effective mechanism for picking up all sorts of things. So a festival license doesn't include a license to have traffic schemes around the festival, but there's no problem with a license saying there shall be a traffic scheme. So the license is capable of picking up all sorts of public safety or public protection issues associated with the licensable activity, as indeed Sefton does in this case, which is a condition that the operator will do their best to get a driver and vehicle there. So that is the way the system works. It is a licensing scheme. It's not a contractual regulatory scheme. Contracts are regulated by other statutes, as you well know, but licensing operates in a different way. Lords, the context and purpose, as you know, since 1847 in the provinces, hackneys and their drivers needed a licence. When a customer steps into a hackney, they know they're in safe hands. They can see it from the driver's badge and the vehicle's plate. Hackneys are defined by what they do, which is to ply for hire. That's exhibit themselves as being for immediate hire, sitting on designated ranks or driving around with their lights on, waiting to be hailed. But vehicles which didn't ply for hire but were booked through operators weren't hackneys and so were unregulated. So vehicles whose hiring resulted from plying, not from plying but from booking, were unregulated. And that was the mischief which Parliament addressed by providing for the licensing control of vehicles and drivers and also operators to protect the safety of the passenger. There was then a definition of the licensable activity, which, as we'll see, all concerns the anterior acts as making provision for invitation or acceptance. And then, importantly, operators had to keep a record of bookings which they took. So bookings were traceable, with the vehicle and driver identified, so that it could be shown that a licensed vehicle and driver were being used and that the hire had resulted from a booking and not from plying. And then if something goes wrong, there's poor or dangerous service, or in Lord Legate's example, the driver behaves in an unethical or high-handed way about prices charged, all of that's traceable, and the licensing authority has powers of enforcement. But when it came to contracting, it's common ground between the parties that the structure of the trade was complex, and there were many different permutations. I'm only going to ask you to note these. I don't have time to take you to them. But Maxwell Stamp at Core Bundle 71, page 1734, 4.61 and 4.62, the Court of Appeal judgment, paragraph 36, Visu's evidence, page 2057, paras 13 to 20, and D.E.L.T.A's evidence, 2060, paragraphs 5 to 26, and particularly 20.
Can you give me the page reference for Visu, paras 13 to 20?
Visu 2057,
Thank you.
paras 13 to 20. But can I just give you some common examples? You understand the multiplicity. The person making the booking might be the passenger booking for themselves, or they might be booking for others, like a parent, or it might be a restaurant waiter or a hotel receptionist booking a cab for a customer, or indeed customers. It could be an education authority or social services department booking for a young or vulnerable passenger. In any of those cases, the booker might be the contracting and paying party, or they might be contracting on behalf of a third party, or they might expect the third party to be the contracting party with the contract coming later. On the other side of the arrangement, the counterparty might be the operator as principal. It might be the driver, direct, or through the agency of the operator, or it might be another operator to which the operator had passed the booking by contract or otherwise. Section 56(2) allows either. The subject of the matter of the booking could be anything from a journey to a hire for a period or just to be on standby. The booking might be, and often is, cab for Mrs. Smith at the Dog and Duck, please. Nothing else specified whatsoever. And the contract might arise at the point of booking, or the booking might simply be a reservation with the contract coming later, such as with the driver, and might even be varied en route. So there are many permutations. And the way Parliament legislated for this is that, having imposed the triple lock by way of regulatory intervention, it didn't purport also to interfere in contractual freedoms. The operator takes the booking. He's made provision for the invitation or acceptance of bookings. He needs a licence. He's got to ensure that the vehicles he works with are licensed and insured, and he's got to make a record of the booking. And then, as I've said, it's inherent in the nature of the booking, the operator will try to get someone there, and then the driver and vehicle who turn up to carry the passenger have to be licensed. They've had their fitness adjudged. But the part in between, all that detail of the contracts, who it's between and when it happens and so forth, are not dictated by the Act. Instead, as the Court of Appeal put it on my submission, Parliament cut through the contractual thicket, simply saying that every contract for a hire of a licensed PHV shall be deemed to be made with the operator who accepted the booking for that vehicle, whether or not he himself provided the vehicle. So Parliament didn't dictate who must be the principal contracting party, or who must be the contracting party on the customer side, or it didn't say there can't be a booking without a contract, or the contract must be at the point of booking, or far less, the booking is the contract, and it didn't set the terms. It didn't need to do any of those things. It achieved its objectives by creating a deemed contract to supplement any contract made in the real world. And actually for good reason, because as we've seen, Uber have put up two different declarations so far. In the High Court, it was the passenger and the journey. In the Court of Appeal, it was the person who made that booking to fulfil the booking. In this court today, it's accepted that the booker could be an agent, but for some reason the operator can't be an agent. That's a further concession made today. And then there have been other key variations in Uber's case, which if I have time, I will identify, as it tries to find some location for this alleged obligation, some statutory language, and retrofit what its unitary contractual device is into this 1976 legislative framework, which actually is concerned with standards and safety and not with contracting. So the answer to this appeal we submit is very simple. Parliament didn't create a statutory obligation on an operator to contract as principle any more than it placed a statutory obligation on a booker to enter into a contract with the operator at the point of booking. What if the person booking doesn't want to enter into a contract? Are they compelled to, or is it unlawful, or can the operator not accept it if it's not a contract? Parliament didn't get involved in all that, and moreover, nor did it criminalise a driver who contracts a customer having been dispatched by the operator. And if Parliament intended to take that contractual freedom away, which is long-standing, it certainly didn't do it by express language. We say it left the parties with contractual freedom, but once there's a contract, it deems it's made with the operator. And I don't claim that's a perfect world. You've raised certain reasons why The passenger might be better off in this way or that way and so forth, but that's not the inquiry here. It's not a policy debate. It's a question of identifying the language which results in Uber's quadruple implication being there on the face of the statute. From my client's point of view, it's been in operation since 1968, operating in exactly the same way. It's always been a free best endeavours booking service. It's always enabled customers to connect with drivers, offering private hire services, contracting between driver and customer. A lot of it is a cash business, so drivers simply collect the fare. It's theirs to collect and theirs to retain. My client has no interest in any of that. Its income is solely from the settle, which drivers pay for the privilege of being on the end of a radio and for the opportunity to be notified of potential jobs. Its legal origin is as an introducing agent, and my client has done it widely across 6 authorities for many, many years. There's another form of the agency model where the operator contracts on behalf of the driver, also referred to in Maxwell's stamp in one of the paragraphs I've mentioned. At least a third of the 15,000 operators in this country, England and Wales, use the agency model. It wasn't adopted by stealth. Its prevalence was known to Parliament in 1976. As we state in our written case at paras 17 to 18, it was a quarter of the private hire trade in Greater London at the time of stamp, and it was recognised as one of the models of operation then. And it's a common ground that it wasn't expressly outlawed by the legislation. And
well, in that case, you've got 56 puts you in the same position in relation to the operator as you are with the drivers. So, if the operator accepts a contract of hire on behalf of the driver, you've got two contracting parties, in effect.
Absolutely. Section 56 covers all eventualities. As Lord Justice Lewison said, Section 56 does all the work which needs to be done. And it's right to say that over the last 50 years, none of the 300 or so licensing authorities in England and Wales, or any tax authority, government department or law commission has sought to challenge the legality of the agency model. And over the years, I appreciate this may not be that helpful to this court, but over the years, HMRC has given guidance on many occasions about how tax is to be accounted for by the driver who collects the fares. That's at pages 1901, 1904, 1938. And it's right to say that even these proceedings didn't arise out of a regulatory dispute or issue. Uber paid Sefton Council to come along as a defendant, so there could be a defendant named. And Sefton came along and said in its witness statement, page 2046, that it had no problem with the agency model, and no 1976 Act regulator has sought to participate in these onward appeals. So my client is here because it wants to defend this business model. It's how it works. It's how it's always worked. And it notes that this challenge is brought not by a regulator at all, but by a trade competitor. And also, frankly, to change the model would carry significant fiscal and other consequences for operators and drivers and customers and authorities. But I don't want to claim consequences as a route to construction. It simply explains why we're here. It's not a policy debate. It's a question of identifying the statutory language. Lords, I wonder whether I should, my lady, I wonder whether I should draw stumps there and come back and look at the legislation at 2 o'clock.
I think at this stage you just remove the bails, don't you?
Yes, we've better remove the bails.
Yes, well, we'll adjourn then and resume at 2 o'clock.